welcome everybody to Fox Williams, particularly everyone who's gathered here in person and those who are joining us online. I'm Andrew Hill. I'm a partner here, and I'm the head of our dispute resolution team. I'm also the deputy chair of the AALS, and who'll speak in a moment is the chair. I'd like to just say a couple of things to welcome you. It always surprises me when I think that I've now been living and practicing in London for 14 years, since moving over in 2012, but I remain a proud Aussie, and I love the fact that at important meetings and ceremonies in Australia, it's now customary, I believe, for the host to make an acknowledgement of country, to pay respect to the connection of Australia's Indigenous population with the land where an event is taking place. And I was very pleased to be able to do that at my own wedding in Sydney 5 years ago. It doesn't really work over here for obvious reasons, I think, but I did just want to acknowledge or draw to your attention, especially given the judge's military connections, that the land next door to us belongs to the Honourable Artillery Company, and the HAC is the second oldest regiment in the world, and I believe it's an active reserve unit. Its main role is surveillance and target acquisition, with the regiment operating 3 patrol squadrons forming part of the 16 Air Assault Brigade, including operations in Iraq and Afghanistan. The regiment also has a huge ceremonial role in London, and sometimes if we are working late here in the office, we get to enjoy the marching band practicing, and on the odd occasion we have the kick of being on a Teams call or a Zoom call with a Chinook or Special Forces helicopter coming into land behind us, which keeps things interesting. I think it must also be one of the most valuable patches of grass in London. Lots of people don't know exists. But anyway, you're not here to hear from me, so I'll now hand over to Anne, who is the chair of the AALS, to formally introduce the judge and my fellow Fox Williams partner, Colvin Stone, who leads our technology practice, for what I know will be a very interesting discussion. So thank you and welcome.
My welcome, of course, says thank you to Fox Williams for hosting behind me, because we're very pleased to be able to offer a nice reception for a very impressive judge that we've come to know in the last few years, Melissa Perry. She has asked me to go light on the CV because she has got a lot of accomplishments. But many of you know her main claim on this is that she's a judge appointed to the Federal Court of Australia. She's been there for about 10 years. She did a PhD at Cambridge, she did a PhD at Cambridge prior, before she returned back to Australia to practice, and she got the York Prize for her PhD. She is expert in a number of areas, so I will go light, I promise, on this. But most recently, in addition to her public international law, the fact that she is the first Deputy Judge Advocate General to I think it's the Air Force in Australia, the first female Deputy Judge Advocate General for that. She has become an expert in AI and has been speaking on this topic for a bit, in recent years on this. Speaking with her tonight is Colvin Stone, who's technology partner here at Fox Williams. And with that, I think I will just hand it over to the people you are listening. You are here to hear. That doesn't go well, but here to hear tonight. So Melissa and Colvin, if you would like to come up, and so.
So good evening, everyone. I am without jacket. So I focus on technology and data, and I'm delighted tonight to be the former act for Melissa. So I've been working in technology for about 25 years. This period that we are facing right now really reminds me of when I started my legal career in 1999, where we saw the the internet as such a disruptive force. Now that disruption now is really AI. And at that time, regulators responded by passing a plethora of legislation, a lot of which is actually still in force today and has been currently updated over the last few years. And they were really trying to regulate what they called the wild, wild west of the World Wide Web. But now we are again on the cusp of a regulatory avalanche. In her talk, Melissa will touch on the need and the challenges of regulation around AI. For my part, I will give some context around what is AI and set out what is happening now from a regulatory perspective in both the UK and the EU. At the end, I'll also facilitate a Q&A, so start to have a think about any questions that you might have. So in terms of AI and the basics, AI is increasing exponentially and now touches many aspects of our daily life, sometimes actually without us even knowing, and that is one of the issues around transparency. It is fast becoming a critical business tool, whether assisting in streamlining processes like credit checking or in terms of filtering recruitment, or as a tool for criminality. So AI is often broken into two categories: narrow AI, which is really designed to perform a specific function, and then general AI, which more closely mirrors human intelligence by learning autonomously and is able to solve different problems in certain contexts. So that's really, if you've seen Ex Machina, think of the AI robot in Ex Machina. And general AI is not really a reality at the moment. So that really won't become a reality until sort of somewhere around 2060. It's what the scientists predict. So at the moment, when we talk about AI, we're really talking about narrow AI. And narrow AI, as I said, is designed to perform a specific function. So generative AI tools such as ChatGPT, which has really kind of accelerated the AI revolution at the moment, that is a form of narrow AI because it generates specific types of content based on the data it's been trained on. And these tools are also referred to as natural language processing programs. Sometimes you'll hear that type of terminology, or large language models. Essentially, what you're really talking about is generative AI. So Melissa will also talk about some of the risks around deepfakes. That's also a form of generative AI because they are relying on deep learning techniques to create highly realistic and often deceptive audio, video, images by really trying to mimic human behavior. AI tools are developed using a process known as machine learning. So prior to machine learning, the output of a system, a software, would really depend on how it's coded, effectively meaning they were constrained by human knowledge because it really depended on what the code could do. So this was quite a time-consuming process. It constrained innovation. But now machine learning can go beyond human knowledge because they can draw their own knowledge and learn by extracting trends and patterns from the data which is fed to them. So this is really how ChatGPT works and large language models. There are different types of machine learning, which I'm not going to go into now. But as a result of the way that machine learning works, huge amounts of data are often required to train these models. And that's one of the issues with AI, because you have this tension between the AI, IP law, and data. And we've seen a number of cases involving AI and copyright at the moment. So turning to the regulatory landscape around AI, technology and data, as I mentioned, it's much like 1999 again, except that we don't have the Millennium Bug. I don't know if anyone remembered that. That was a bit of a damp squib. But as is the case then, the EU is really leading the way in terms of regulation. And I'm just going to give you a very high-level summary of kind of what's happening at the moment in terms of EU law, and just canter through some of the laws that have been passed recently or will be passed and enacted in the very near future. So firstly, the EU AI Act. So that's the act that aims to regulate AI systems kind of generally. So it's based on three different types of system, what they call prohibited AI, high-risk AI, and low-risk AI. Prohibited AI says what it does on the tin, really, and it bans certain types of AI. Some of that AI is, you wouldn't call that sort of common use AI. The category that's really interesting to everyone is the high-risk AI, because that will seek to regulate things like credit scoring, use of AI in recruitment, some of the more common use types in terms of AI. The EU AI Liability Act. So that's designed to make it easier for victims of AI-related harm to seek compensation. So that's particularly in cases where causality of harm may be difficult to prove because of the complexity of AI systems, because often with an AI system, it's a sort of multiplayer environment. So it's quite hard to work out actually who is responsible. So this Liability Act is designed to make it a lot easier for individuals, consumers, to bring compensation claims where they suffer harm. The EU Digital Services Act, also known as DSA. So this regulation introduces new obligations for online platforms and digital services to really tackle illegal content, ensure transparency, and ultimately it's designed to protect individual users. The EU Data Act. So this legislation focuses on making data generated by connected devices accessible to users. So it's really designed to ensure kind of data portability. The EU Data Governance Act. This establishes a framework for data sharing across different sectors and borders in the EU. NIS2 directive, that updates the NIS directive, which is really focused on cybersecurity. The EU Cyber Resilience Act. This sets out cybersecurity requirements for products, so physical products, and again, is designed to enhance the safety of those physical products that consumers use for connecting to the internet and general other kind of online use. The Digital Operational Resilience Act, also known as DORA, and that's really focused on ensuring that regulated firms in financial services put in place enhanced cybersecurity measures. That gives you a very quick flavour of what is happening at an EU level in terms of regulation. In the UK has enacted the Online Safety Act, which is really the kind of UK equivalent of DSA, the Digital Services Act, again, which is really focused on ensuring that online platforms have a duty of care and respect to consumers, and basically put in place safeguards to ensure that they're protected online. In terms of AI, the current UK government has said that it will look to ensure the safe development and use of AI models by regulating companies that are developing the most powerful AI models, and by banning the creation of sexually explicit deepfakes. There's no kind of detail around what they are doing, but what they are looking to do is regulate certain types of what they will deem to be high risk AI systems or AI models. That's quite a different approach from obviously the EU, which is taking, as I said, a very comprehensive approach to legislating. It's also a departure from the previous government, which preferred what it called a pro-innovation approach. I think it was really designed to try and differentiate the UK from the EU in a sort of post-Brexit world. And they basically decided not to regulate AI. But you can see, even though the current UK government is proposing to regulate, it is very different from the EU approach, which is, as I said, is sort of comprehensive and all-encompassing. And I think herein lies a major issue, which Melissa will touch on, in that the challenge of regulating AI and tech in a global market when it is also quite fractured from a geopolitical perspective, and then at the same time trying to ensure a level playing field for businesses to develop innovation and new tech, because essentially these laws are still localized. They're still sort of territorial in nature, and obviously also enforcement is still primarily local. And it's really the EU that's leading the way in regulation, as it did in 1999, but it's not necessarily leading the way in terms of innovation. And on that note, I will hand over to Melissa.
Thank you very much. Thank you very much, Anne, and also Colvin. That is an excellent context for what I'm going to lead into, but I'm going to go engage in some historical forays, as you'll discover on the course of our journey. So my foray into the intersection between machines and the law began in 2004, when I was appointed to the Administrative Review Council, which reported to the Attorney General on the health of the federal administrative law system in Australia. And it was the title of their latest report which piqued my interest. What I thought is automated decision-making. As far as I'm aware, that report was the first worldwide to consider what legal and regulatory frameworks should govern the use of automated decision-making processes, relevantly in the context of that body, in government decisions affecting the rights and interests of individuals and corporations. The foundation for the recommendations in the report were the primacy of the rule of law and fundamental administrative law values, including transparency, accountability, procedural fairness, and legality. And these are values which continue to underpin current developments internationally with respect to the creation of legal frameworks for the design, development, and operation of AI systems. Broadly speaking, systems have evolved from automated decision-making to machine learning, which, as we've heard from Colvin, involves machines detecting patterns in data, to AI in its current form, whereby machines exhibit or simulate human intelligent behaviour based on predictive or probabilistic outputs derived from data sets. Now, this isn't to suggest that there's been a succession of technologies in the sense that one superseded the other. Rather, these technologies constitute broad classifications within a fast evolving family of technologies, which may work in combination depending on the particular system. Further, the development of quantum technologies, a critical emerging technology, will bring with it ever more powerful computers and global communication networks. So it's no surprise that governments should seek to utilise these technologies across the broad spectrum of activities, with hundreds of millions of decisions made by government in Australia alone every year using these machine technologies. And this is a trend which no doubt we will see continuing in line with the rapid growth in the volume, complexity and subject matter of decisions made by government affecting public and private interests, given their capacity to promote consistent, accurate, cost-effective and timely decisions. And this expansion, of course, is mirrored in the private sector. Indeed, it was estimated that in 2023, AI may contribute 22.17 billion to the global economy. Yet hitherto, the astronomical rate of change and scale of developments in machine technologies has outpaced the capacity of humankind to develop the moral, ethical, legal and philosophical frameworks within which such technology should be designed, developed, deployed, used and decommissioned. It's therefore no overstatement to say that we're at a pivotal point in human history, confronted with the reality of machines of exceptional power, which are capable of being harnessed for the betterment of humankind, but also capable of great harm. These capabilities are effectively supercharged by the means by which we communicate and share information in a virtual world. So it's on this context that I'm proposing to focus today, with references, where appropriate, to collaboration between the UK and Australia. So I hope you'll indulge me in, as I indicated, taking a short diversion to another pivotal moment in the history of technology. That moment is the completion of a submarine telegraph cable by the British Australian Telegraph Company from Port Darwin to Java in 1871. In a contemporaneous account, William Brackley Wildey observed that Captain Halpin, who was in charge of the ships comprising the cable expedition, announced from Java that the cable was complete and in perfect condition, and that telegraphic communication was established between Australia, England, and the Western world. The cable consisted of a central copper wire with 6 copper wires twisted around it, insulated by a substance that probably none of us have heard of, known as gutta percha, tarred hemp, and galvanized iron wire, with the deep sea portions only 3/4 of an inch in diameter. Shortly after these events, in 1873, the overland telegraph line from Adelaide to Palmerston, as Darwin was then known, was connected to the newly completed submarine cable at Port Darwin. The vast distances which communications were required to travel within Australia and from Australia to the rest of the world could now be bridged in a matter of hours instead of months. Australia was no longer truly an island. Mr. Wildey also wrote that it is a remarkable fact that although the cable can be seen whilst the operators thereby receive and flash the news to the various colonies, yet not one atom of intelligence ever ekes out. Now, Australians embraced this new technology, sending by the late 1890s more telegrams per person than any other country, despite the fact that each word cost the equivalent of a day's wage for a labourer. Their messages were then translated into the combination known as Morse code of dots, dashes, and spaces, representing letters of the alphabet and numbers, and were transmitted as electrical impulses to be decoded at the other end. Now, ensuring that the lines of communication opened by this transformative new technology were protected required international cooperation. The cables crossed vast oceans to connect different nations and their then colonies around the globe. On 14 March 1884, the Convention for the Protection of Submarine Telegraph Cables was signed in Paris, coming into force not long thereafter in 1888. Its parties included the United Kingdom and thereby applied to the then colonies of Queensland, South Australia, and Victoria. Now, the emphasis was on protecting the submarine cables, with the convention declaring that it was an offence to willfully or negligently break or injure a submarine cable. Article 10 in turn afforded rights to officers of state parties to require another vessel suspected of committing an infraction to furnish evidence of its nationality, and offences were expected to be prosecuted domestically by the state parties under locally enacted laws, a framework not so different from those that we see in other conventions today. Many years later, on December 7, 1941, these same submarine cables carried an urgent and terrible message to be relayed to the Australian government. The US naval base at Pearl Harbor was under attack by a surprise aerial attack by the Japanese. My grandfather, who was then employed by the Cable and Telegraph Company in Darwin, was the first person on Australian soil to receive that message. Today, over 98% of the world's data travels along 485 submarine cables connecting all continents, with the exception of Antarctica. and spanning the Atlantic and Pacific Oceans. Now, Australia currently owns or operates approximately 400,000 kilometres of these cables, which is sufficient, according to one commentator, to lap the world 10 times over. Further, some of these cables have been laid thousands of metres below the surface of the ocean, with one connecting Australia to Guam, crossing the Mariana Trench, which is, of course, the deepest trench on Earth, with a depth of approximately 11,000 metres. You can tell I'm a bit of a fact nerd. While the 1884 Convention remains in force, the protection of submarine cables and the freedom to lay and operate them came to be primarily governed by the 1958 Geneva Conventions on the high seas and the continental shelf. And while the United States is not a party, in time by the 1982 United Nations Convention on the Law of the Seas. Significantly, Article 113 of UNCLOS requires every state to adopt laws making it a punishable offence to break or injure submarine cables beneath the high seas, either willfully or through culpable negligence. It also requires states to adopt laws and regulations to reimburse persons whose cable was broken or injured by someone who's subject to the state's jurisdiction. The importance of taking steps to mitigate the risks of damage to submarine telecommunications cables by Australia and the UK within their respective territories was also expressly recognised in Article 12.14 of the Comprehensive Australia-UK Free Trade Agreement, which came into effect last year. Damage caused to undersea optic fibre cables from the anchor of a cargo ship, which was recently attacked by Yemeni Houthi rebels in the Red Sea, is an example of such risks and highlights, as one commentator has said, the complex interplay between geopolitical conflicts and the security of global internet infrastructure. Submarine communication cables remain central to global communication, but now contain optic fibre in place of copper. The transmission of data from these cables via radio waves from the modem to your laptop frees the data from the limitations of physical conduits, while rendering the data more susceptible to be hacked. Thus, in contrast to Mr. Wildey's observation in 1871 with respect to telegraph and submarine cables, sadly, it cannot be said of the internet that not one atom of intelligence ever ekes out. Furthermore, multiple terabits of data are transferred every second via submarine cables and 2,500 satellites, with social media and news platforms facilitating the mass transmission and sharing of information globally by the roughly 5.3 billion internet users worldwide. The challenges posed by AI are, one might say, supercharged by reason of the radically different environment in which communication is effected today. It is this environment which I've described as communication highways, which amplifies, for example, the risks posed by deep fakes to spread misinformation and propaganda. However, as the ABA Task Force for American Democracy stated in May this year, when used maliciously, deepfakes can distort reality, undermine trust, and destroy reputations, with potentially dire consequences for democratic processes. The use of doctored images to mislead and spread propaganda or misinformation is not new, as is evidenced by the practices of a number of modern dictators. The example on this slide depicts the removal from a photograph of the head of Stalin's secret police, Nikolai Yezhov, following his execution. Another example is the notorious photograph erasing Goebbels, leaving Hitler standing next to a ghostly absence, as it's been described. More recently, in 2008, a photograph of an Iranian ballistic missile test was altered so as to conceal the fact that one of the 4 missiles had misfired. But what is new is the capacity of deepfake software, now freely available online, to convincingly manipulate videos and recordings based on training from photographs, recordings and videos readily available on the internet, such as news sites and social media accounts, and for deepfakes to be shared and reshared instantaneously via social media and other platforms to an unlimited global audience. Further, the platforms that are used to promulgate deepfakes are designed to spread information more quickly than fact checkers can operate. Added to this, the ability to disseminate deepfakes en masse through multiple information sources makes them appear to be more credible and therefore more likely to be accepted as true. Improvements in deepfake technology also mean that it can be very difficult to differentiate between deepfakes and real recordings, photographs and videos. Indeed, deepfakes can now be used in real time as if they are conducting a conversation on an online platform with a human. So as this indicates, the problem is not, therefore, merely identifying the deepfake. It can also be in believing what is real. In other words, as one leading commentator, Professor Lillian Edwards, has observed, the problem may not be so much the faked reality as the fact that real reality becomes plausibly deniable. The increasing inability to differentiate between what is real and what is not is particularly chilling, given existing conflicts, expanding foreign influence utilising AI, and the heightened risks to global peace and security which currently exist. Indeed, the Global Risks Report 2024 by the World Economic Forum placed the likely adverse impact of misinformation and disinformation over the next 2 years through the adverse use of AI as the most severe global risk to world stability, over such risks as extreme weather events and interstate armed conflict. I must say that shocked me when I read that. No institution is immune from these risks. By way of an example close to home from my perspective, the increase in live streaming of court proceedings and otherwise by audio-visual means promotes the fundamental value of open justice in our common law systems, but also carries with it risks. The dissemination of deepfakes of court proceedings would almost certainly constitute a contempt of court. But it cannot be assumed that this is an adequate deterrence for those who seek to conceal their digital identities, such as foreign actors and others with malign intentions. Deepfakes pose significant opportunities for scammers to exploit individuals and corporations on a global scale, with worldwide losses from scams and bank fraud schemes totaling $485.6 billion in 2023, according to a NASDAQ report. They also afford significant opportunities for foreign actors to spread propaganda. A recent example is the fake documentary called Olympics Has Fallen, which is narrated by an AI-generated audio of Tom Cruise and promoted by bogus 5-star reviews, not only from the New York Times, but I'm afraid to say the BBC. The fake video seeks to disparage the IOC and is apparently produced by a Kremlin-linked group, being intended as part of an anti-Olympics campaign. And this also included fake news broadcasts to spread fear of terrorist attacks at the Paris Olympics. Further, last week, the US Departments of Justice, State and Treasury announced coordinated actions to aggressively counter an extensive campaign by Kremlin-backed media executives and broadcasters to interfere with the presidential election. One of the fake reports prompting this action may well have been the fake report of the Ukrainian First Lady purchasing a rare sports car with monies sourced from US military aid. This was picked up and spread on social media and viewed by between 6.5 and 12 million people. And this morning, following the US presidential debate, Taylor Swift, together rather pointedly with a photograph of herself holding a very glamorous and fluffy cat, posted her endorsement of Kamala Harris and Tim Walz, in part to refute AI-generated material, which had been circulated online, depicting her and Swifties endorsing Donald Trump. It's therefore no surprise that the Bletchley Declaration, signed last year by 27 states, including the UK and Australia, expressly noted the potential for unforeseen risks stemming from the capability to manipulate content or generate deceptive content, and emphasised the urgent need to address those risks. What then of the responses to controlling the potential for mass dissemination of misinformation and disinformation by such means? From the time that Hitler came to power in 1933, the Nazi regime effectively harnessed the dual power of censorship and propaganda, including through the broadcasting of Nazi speeches on radio and by making radios more affordable within Germany. It's therefore no coincidence that the International Convention concerning the use of broadcasting in the cause of peace, 1936, apparently the first international attempt to regulate the content of mass communications, came into force in 1938 on the eve of the Second World War. Among the small number of state parties were Great Britain, France, Norway, and Australia. By that convention, the state parties undertook to prohibit transmissions likely to harm good international standing by inciting the population to acts incompatible with the security of other state parties or to war with other state parties. They also undertook, especially in times of crisis, to broadcast information concerning international relations, the accuracy of which had been verified by those responsible for broadcasting the information. While Australia, the UK, and a number of other states have since withdrawn from this convention, the threat posed by misinformation and disinformation to our democratic systems, our economies, and our societies more generally remains, but now through online platforms. Now if not the primary source of news for the population globally. International cooperation has also led to the development of international instruments, specifically in the AI space, for governments and private entities, which build upon each other. The first such intergovernmental standard was the recommendation on AI adopted by the OECD in May 2019. This was updated earlier this year. The OECD principles make recommendations not only for governments but for AI actors, being those who play an active role in the AI system life cycle, including organisations and individuals that deploy or operate AI. Those principles are intended to promote harmonious global AI governance, recognising that, of course, these technologies know no boundaries. Building on the OECD principles, in November 2023, the UK government hosted the AI Safety Summit at Bletchley, the birthplace of the modern computer. For it was at Bletchley Park, of course, that Alan Turing and other scientists broke the Nazi Enigma code. This brought together government representatives, leading AI companies, civil society groups and experts in research, with the composition of the summit itself recognising that the creation and implementation of legal regulatory frameworks requires collaboration not only between states, but with stakeholders and experts across a raft of disciplines. Among other, the non-binding agreement, which was the Bletchley Declaration, recognised not only the opportunities potentially afforded by AI to transform and enhance human well-being, peace and prosperity, but also recognised the potential for serious, even catastrophic harm, either deliberate or unintentional, stemming from the most significant capability of these AI models. The EU AI Act, which came into effect on the 1st of August, constitutes a significant legal milestone in AI regulation. We've already heard something of that in the overview of regulation in the EU given today by Colvin. It comprises a detailed regulatory regime focused on mitigating the risks of high-risk AI systems through measures such as requiring risk and quality assessment systems, human oversight, and third-party assessment before being sold or used in the EU. It also prohibits certain AI systems capable of significant harm for malevolent purposes. While not binding on non-member states, the EU AI Act nonetheless has potential relevance well beyond the jurisdictions of member states. Among other things, this is because of its capacity to contribute to the development of customary international law and its application to developers and deployers of high-risk AI systems, where the system or its output is used in the EU, regardless of where the developer or deployer is based. Finally, the first legally binding treaty to regulate AI, the Law Council's Framework Convention on AI, opened for signature on the 5th of September. This convention is open to signatories outside the EU and is intended to respond to the urgent need for a globally applicable legal framework. Among the first signatories are the UK and the US, as well as the EU, and while not yet a party, unless it happened just yesterday, Australia was among the non-member states comprising the intergovernmental body which prepared the treaty. The treaty expressly builds on the earlier themes embodied in the OECD principles and other international instruments to which I've referred. But of its nature, the Framework Convention is not prescriptive in terms of the means by which its aims may be achieved by parties domestically. It is in this sense, therefore, a very different document from the EU AI Act. However, in line with that Act, the Framework Convention imposes obligations on state parties to adopt measures to assess and mitigate potential risks and adverse impacts on human rights, democratic systems and processes, and the rule of law from activities throughout the life cycle of AI systems. However, the excluded from the scope of the treaty are systems deployed in the protection of national security interests and matters relating to national defence. So, the present is a brave new world, grappling with technologies beyond the imaginings of Captain Halpin when announcing the establishment of telegraphic communication from Australia to the rest of the world in the late 19th century. What was once science fiction is now reality, in the ongoing and unstoppable process of ever-evolving technologies. The challenges for us all lie in ensuring that fundamental human rights and values, our democratic institutions, and our humanity are protected, as neither our means of communication nor emerging technologies are confined by state boundaries. This requires continuing urgent international processes of collaboration, information exchange, and the development of standards applicable throughout the life cycle of these technologies and the domestic implementation of such standards. So thank you very much.
So just moving to the sort of Q&A section of the evening. Does anyone have any questions for Melissa? So this issue of technology and it being borderless, but
Yes.
ultimately countries are, sovereign and they act ultimately according to their own interests. I mean, we've seen this a little bit with the UK and the EU. The UK left the EU, and in the context of AI regulation, the EU have gone in one direction and the UK have not followed. It's going to change, I think, with the new Labour government. But the sort of rationale behind that was to really try and make the UK business friendly, and by that, regulatory light to the point where there was no regulation. And that was very much a kind of policy decision from the UK government. When you have that kind of context and the issues that we're facing globally, how do you regulate something like AI globally? I mean, you mentioned some of the treaties, but do you have any suggestions on how we might approach this from a sort of global societal perspective?
It's a really important question. And one of the significant aspects of the new framework convention is that the UK is a party to that. And of course, the framework convention, as I said, doesn't try to be prescriptive, but instead leaves it to the states, being fully respectful of their sovereignty, to work out how to domestically implement, give effect to the principles in that act, in that treaty. So it is significant that the UK is one of the first parties to that, and I think it was in the Intergovernmental Panel that was involved in preparation of the treaty over a 2-year period. And I think that's the only way in which it could happen. It's a bit, in some ways, it reminded me a lot of the sort of framework convention that we had with climate change, and that we also see more broadly in the environmental sphere, where states, having agreed to a set of principles, then go their own way in terms of determining how to implement that, having regard to their own particular jurisdictional concerns and complexities. But another aspect of the treaty, the framework convention, which was interesting and caught my attention, is that it required states either on signing the convention or on ratifying the convention to actually set out in a statement how they were proposing to give effect to the convention. Now, I know we have some very expert international lawyers here, but I thought that was an interesting and rather unusual approach. And it was sort of saying, well, if you're going to subscribe to this, you've actually really got to put your money where your mouth is. You've got to tell us up front how it is that you're proposing within your own jurisdiction to give effect to it. So that's sort of this, and of course, as I indicated, while the convention is concerned to address risks, there's also some aspects of it which are intended to promote the development of AI systems. But a lot more happened with respect to the more positive aspects of AI. And as I said, there are a lot of predictions that it has the capacity to massively, to have a massive positive impact on the global economy. You have individual initiatives, like in the UK-Australia Free Trade Agreement, there's quite a lot about sharing of information and development of technologies. And Australia and the UK also, at the time of the Bletchley Declaration, agreed on a, I can't remember, statement, I think it was called, dealing with respect to quantum technologies. I'm sure you're aware of it, and they've agreed to, again, share information and take certain steps to promote that kind of technology as it becomes available, and use it, and its use in a responsible manner. So you do have, as you've quite absolutely spot on identified, a tension between, on the one hand, the positive benefits that we can see likely to come as a result of AI and already being realised, but we also have the negative aspects of it, which have to, I think all states now recognise, have to be addressed, because otherwise the consequences could be the breakdown, among other things, in our very systems of government.
Following on from that, on that theme, there's a real difference, I believe, between different parts of the world, and the EU is one of the more advanced jurisdictions to regulate AI. The United States has got some tension in, it's got some initiatives towards trying to rein it in, but it's also trying to keep it open vis-a-vis Russia, China, who are really trying to keep the limits off regulation of AI so that they can win this new war in how advanced how far they can push it out, to the point where even I think Elon Musk is calling for the regulation of AI. So I was wondering if you could talk about some of those differences a little further.
Yeah, it's a sort of similar theme of this sort of trying to create a living level playing field. I mean, Elon Musk is a bit of an enigma, because on the one hand he calls for regulation around AI, but at the same time, I mentioned some of the laws that have been passed to promote online safety, and that's specifically around misinformation. But he is flatly refusing at the moment to comply with current rules around, misinformation. So, a lot of it is coming from deep fakes and AI technology, yet he's not implementing any systems to either voluntarily address that, but to comply with existing rules. I know the UK government are trying to engage with him in order to comply with the existing regime around kind of online safety. So he's, like I said, somewhat of an enigma. It is a challenge, this, because it is somewhat of an arms race. And the last time I was in China, they are a world leader in facial recognition technology. It's incredible what they do. The EU, strongest privacy laws in the world, and which I think is important. Not anywhere near the capability that the Chinese have, and there's one of the reasons for that is the different regime in terms of regulation and the incentive of the Chinese government to develop technologies around facial recognition technology, because it's a form of kind of social control. So this tension between regulation and innovation is real, and I think everyone is struggling to grapple with that at the moment. As I said, the UK very much
has adopted a very light touch approach. I think you touched on the US. The US is also following a sort of similar approach to the UK at the moment. I feel like they're kind of waiting to see and how long can they keep their current approach before they're forced to kind of regulate. So I feel that tension between regulation and innovation and creating there's the disincentives there to create a level playing field, because certainly the UK and the US are very much trying to be kind of pro business.
I think that's, I would agree entirely with what you say. Interestingly, though, China was a signatory to the Bletchley Declaration. I thought that was, one can't read too much into that, I think, but it certainly struck me at the time as being perhaps an interesting development. Of course, too, there are very different approaches to human rights and to the interpretation of human rights in international law by some countries like China, take, for example, the EU. So you might appear to have perhaps more agreement than you might actually have in reality. But I did take that as a hopeful sign. The technology that you spoke about with facial recognition as well, of course, has been exported by China to quite a large number of other countries. And so this whole move towards surveillance in more autocratic systems is probably a really concerning one, I think, deeply concerning. And we've seen that kind of software being used extensively, for example, in relation to the Uyghur population, allegedly in China. Yes.
Judge, just on that facial technology aspect, you're obviously aware that in England and Wales, facial technology is used quite a lot in criminal cases and is very encouraged by the prosecuting authorities. But just, could I ask, does Australia have a light touch approach that England and the United States have, or is it a bit more prescriptive?
Are you speaking more broadly or just with respect to facial recognition?
Broadly.
Broadly. At present, I think Australia is playing catch up, and the touch is very light. But we do have significant amendments to the Privacy Act in the pipeline. There is a bill currently before the Parliament. And Australia, having been so actively involved in the preparation of the Framework Convention, one would tend to assume is intending to implement those principles, which there's also been a huge amount of concern around the use of deepfake technologies to produce pornographic images, including, tragically, child pornography. And I think this is an area where the government will crack down very, very hard. So I think Australia will gradually take a selective but more prescriptive approach. At the moment, I haven't seen any indication it would take anything as strong as the approach taken by the EU.
And do you think that'll be a federal matter, or will that be a state matter?
Look, it's probably likely to be both, because obviously, as you'd be aware, with our constitutional system, the states have all the residual powers, everything except what the Constitution takes away, which isn't very much. So if they feel that there are areas that need regulation, they will move on them. But just like international boundaries are not respected by these new technologies, equally national boundaries are not. And so one would have thought far preferable for a national approach to be taken.
Thank you very much.
You sort of touched on the EU AI Act and the fact it has this kind of extraterritorial effect.
Yes.
Which is very similar to the GDPR. And the EU have done an excellent job in terms of exporting GDPR around the world. partly using that. We see lots of countries implementing GDPR type legislation. Can you see that happening with the EU AI Act and countries following that kind of model?
I think I think that's very likely. At least those parts of it that they feel they wish to, and the general approach of really just leaving AI development largely to its own devices, save where it has likely high-risk impacts, is one that will resonate quite strongly. The Framework Convention leaves it open to state parties to decide for themselves what might be the real high-risk AI systems, but one would hope that there'll be a high measure of agreement with that. And that's quite likely to accord with those categories identified in the EU AI Act. So I think it will be very influential, but it just may take countries a lot longer to get there. It's an enormously complex piece of legislation, I found, but it did have a wonderful software program that enabled you to navigate your way around the AI Act a bit more easily.
Using AI?
Using AI, I suspect, yes, using AI. So, but interestingly, given the legal focus of most of us who are present here, the administration of justice is one of those categories which is identified as a high-risk area for the use of AI systems, including legal research. And we had an example recently in the newspapers of inadvertent disclosure of legally privileged information when someone who was conducting a seminar on sexual harassment typed into ChatGPT, "Can you give me a hypothetical scenario involving X, Y, and Z?" ChatGPT came back and gave her the hypothetical scenario. She typed back into it, "Can you please confirm that this is not real?" And ChatGPT replied, "No, this is not real." So anyway, she held the seminar, put the hypothetical up on the screen, and there was a screech from the back of the room. It was real. And it wasn't just real, it was a matter that was currently under investigation in the company itself, subject of a confidential inquiry. So I thought that was a really interesting example of the high risks that there can be in using technologies without having properly looked at assessing the risks for us as lawyers.
Any additional questions?
Yeah. I was wondering if you could speak to how you see AI being incorporated in the judicial process from your role, for instance, or throughout the judiciary more broadly. Do you see it as just a kind of procedural element, given the, as you just mentioned, some of the dangers that there are? Is it best for it to be safeguarded just to that? And then beyond that, what role does the judiciary have in kind of shaping the future of a safe AI? Should it be left to the legislative?
Well, that raises a whole bevy of really interesting issues. A very, very astute question. At the moment, there are quite a number of courts which have developed guidelines and practice notes around the use of AI by the legal profession, by unrepresented litigants, and by judges. And those have tended to explain, often in very clear lay terms, what the actual technology is, particularly with generative AI which uses large language models like ChatGPT and BART, Google's BART. But it's largely saying, warning people off using it and warning them of the capacity of generative AI to hallucinate or produce absolutely false information, and do so in a very convincing way. But obviously, we are seeing now, I think that there is a role for it to be used openly by unrepresented litigants
in the preparation of written submissions. That may be something that we see, because people who may otherwise not be able to put their submissions in a persuasive form might recover a little bit more of a level playing field by using some of these technologies. But it should, if that is a road that we go down, then it would need to be attended with proper disclosure, so that we knew we weren't dealing with the submissions that were coming from the mouth of the litigant, but that they had been generated by one of these processes, and that the litigant actually understood what they said and agreed with it. But to use it in the preparation of evidence would be an entirely different, leaving aside expert evidence, is an entirely different kettle of fish. And I'm a very strong adherent to the view that a witness's evidence in written form should be their words. And yes, guided by a lawyer to ensure relevance and structure and so on, but must be in the witness's own words. So I wouldn't see that as being a possible use. And the other area, obviously, is the area of legal research, and it's incumbent on law librarians, particularly in purchasing these systems for use within courts, and no doubt also law librarians and information officers within law firms, to properly investigate issues such as, does the system retain the information, the prompts that are input, and so forth, in order to determine how they can safely be used. It's almost going to be impossible, I think, now. I don't know what your view is, Colin, but I think it's almost going to be impossible to undertake legal research using any tool without there being some form of AI being embedded in that system.
Yeah, I think that's right. The challenge is, and you can configure AI, including ChatGPT in this way, is really the resources that it interrogates. And we've had situations where people have used ChatGPT or ChatGPT-like technologies to create legal briefs, and it's made up cases. Yeah. So that, with one of the risks of AI is it can hallucinate. And we're still at relatively early stages, I think. But yeah, there was one situation where in a legal brief, it just completely made up a case. So that's obviously a risk from a legal research perspective. I think there was one other question, and I think then Andrew's giving me the nod. It's time. It's time for a drink. Yes.
Yeah, I think mine's fairly quick. I think with the speed that AI is progressing, I'm just wondering how the legislation can keep up with that. Is it able to do that, the legislation and the speed of progression of AI?
I can certainly give you a quick initial view. I mean, that's always been a challenge. The law always lags behind technology. I think certainly from a UK and EU perspective, the legislators have been very careful to try and develop rules in a technology neutral way. And you mentioned sort of principle-based legislation. So we see that quite a lot at the moment. So therefore, it's not so dependent on the precise technology that's being used. It's a flexible kind of principle-based framework that you can apply to lots of different technologies and use cases. So that, I think, is the principal way in which legislators and governments really try and anticipate this sort of rapid technological change that we see at the moment. But I mean, I read out a whole list of regulation, even though they are developing legislation in this sort of technology neutral way. There's still this need to regulate certain kind of use cases and risks in a specific way.
Yeah, I would agree with that completely. And I think that they'll probably continue to tweak the definition of AI to ensure that it's staying across what new technologies are capable of doing. But if you actually look at the definition of AI in the OECD principles, which has been adopted in the Framework Convention, it's very much looking at the functional aspect of it. What is it producing? It's taking an input and then it's producing an output, which can potentially influence the real physical or virtual world. It's a very broad definition, but I think that they will continue to tweak that definition because that will define the scope. And then otherwise, a lot turns on the actual application of the legislation. So that's why there's identification of high-risk categories like administration of justice. And then there is an assessment process which has to be undertaken of what are the risks of that particular system, and how can those risks be mitigated, or indeed can they be mitigated if used in that context. So by ensuring that the legislation, as you put it, articulates the principles, and I would say also the process that needs to be undertaken, ultimately you are applying that, it directs you to apply those principles and those processes to very specific systems in their context. So you will always look at the individual case in all of its circumstances.